In today's case, we step into a courtroom where confidence meets consequence. A defendant boldly chooses to represent himself, convinced he understands the system well enough to navigate it alone. But the law has a way of testing that confidence quickly. As the proceedings unfold, sharp words are exchanged, patience runs thin, and the reality of courtroom procedure becomes impossible to ignore. This isn't just another hearing, it's a reminder of how fast control can slip away when preparation falls short. Let's take a look at how it all unfolds.
Now calling City of Pontiac versus Philip Colton, case number 23 TRD 802. Good morning. Mr. Colton, did you understand all of the rights and plea options I explained to everyone?
For the most part, if I'm not wrong, I am entitled to a crash report or an accident report, I should say.
Well, if you're not wrong, then you want to plead not guilty today, right?
Yes, sir.
Okay, so, and that can be obtained by you and or your attorney from the law director or the prosecutor's office.
I have asked, I've went to records and it is not available.
Okay, well, we can deal with that later.
Okay.
This is your initial appearance hearing. Did you have any questions about the rights and plea options I explained to you earlier?
No, sir.
Did you receive a copy of this traffic citation that was issued on November 4th, 2020?
Yes, yes, sir.
Okay, you are charged with one count of stopping after or failing to stop after an accident or leaving the scene of a crash or accident. A violation of section 335.12A1 of the Pontiac City Ordinances. If you're convicted of this offense, it's first-degree misdemeanor. If you're convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand that?
Yes, sir.
Also, if there is anyone who is damaged as a result of your actions and you're convicted of this offense, the court could order restitution, order you to pay restitution to that victim of up to $5,000. Do you understand that as a possible consequence? Finally, if you're convicted of this offense, you face a minimum license suspension of 6 months up to a maximum 3 years. So do you understand that as a possible consequence? And how do you wish to plead to this charge? The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
No, sir.
Okay, will you be retaining an attorney?
No, sir. I'll be representing myself.
That's not a wise thing, Mr. Colton, to represent yourself. You're not an attorney. You don't know the legal processes. So I
do have that right, though, right?
You sure do.
Having the right to make a choice doesn't make that choice wise. Stepping into a criminal courtroom without legal guidance isn't a show of strength, it's a gamble with serious consequences on the line. When potential jail time, financial penalties, and the loss of driving privileges are at stake, confidence alone is no substitute for preparation or expertise. This moment highlights the difference between exercising a right and understanding the weight of the risks that come with it.
So you wish to represent yourself?
Yes, sir.
Do you read and write English for the record?
Yes, sir.
I'll provide you a document. It's entitled Waiver of Counsel. Take a few minutes to read it. If you find it acceptable, you can sign and date at the bottom. The court finds the defendant has executed in open court the written waiver of counsel document. In this case, Mr. Colton has decided to represent himself, so he will be pro se. Okay, Mr. Colton, I do not have a written bond recommendation from the prosecutor or law director, as this was a citation issued by the police officer, so I have to ask you a few questions. Do you live, the ticket has you at West Main?
Yes, sir.
What's the apartment number?
37.
37 in Pontiac. How long have you lived there?
4 years.
4 years? Let's see, Mr. Colton has no prior criminal history in this court. His last traffic violation was back in 2008. Mr. Colton does not represent to be a flight risk. I will set bond in the amount of $5,000 personal recognizance. And I will set this case for a pretrial conference in the near future. We're being released on your own recognizance, Mr. Colton. You're going to go, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. That will be the only notice you receive from the court, so make sure you put it on your calendar. If you fail to appear for that hearing, I'll revoke your bond and then I'll issue a bench warrant for your arrest, okay? You could also, the city of county, have $5,000 if you aren't here when you're supposed to be here. Do you understand?
Yes.
Do you have any questions for me?
Yes, I do.
This is the point where the situation takes a meaningful turn, because the courtroom operates within very clear boundaries. A judge's role is to ensure procedure is followed and fairness is maintained, not to coach either side on strategy or provide legal guidance. When those lines are misunderstood, frustration often follows, but the structure exists to preserve neutrality and protect the integrity of the process for everyone involved.
I am not your attorney. I am not your legal advisor. So if you're going to ask me, like you're not the first one who's going to ask me legal questions. I cannot answer your legal question, only procedure. So you have any procedural questions for me?
Yes, I do.
Go ahead.
I would like to know why I am not getting an accident report.
Mr. Colton, you're going to represent yourself. There are what we call rules of discovery. So I would advise you to talk to the prosecutor or law director's office, which is across the hall, and then they'll provide that to you.
Is there a reason you can't?
This is where we get into the situation where a non-lawyer isn't familiar with the procedures. The court doesn't provide discovery. Discovery is exchanged between the parties.
How come the records office will not give me a copy?
Talk to the law director's office. Okay?
At this point, the matter could have concluded smoothly. The instructions were clear, the process explained, and the choice to proceed independently had been respected. Yet instead of moving forward constructively, the situation veered off course, proving once again how a single impulsive decision can undo clarity, escalate tension, and turn a routine proceeding into an avoidable spectacle.
Get back in here.
Sir, get back in court.
Sit down. What's your problem?
I believe I'm getting ready.
If there was any sense of unfair treatment here, it was self-inflicted. Moments like this highlight how composure and judgment matter just as much as argument, especially before a firm, no-nonsense bench. A careless display of theatrics doesn't strengthen a position. It erodes credibility instantly and turns an already delicate situation into one that works entirely against the person creating it.
You just pled not guilty to a charge. I found you not guilty. I've accepted the not guilty plea. Be quiet! Be quiet! Or I'll hold you in contempt of court. Now, why do you feel railroaded? Because you went to the police department and asked for a copy of the report. You went to the wrong office. And any attorney would know that. You go to the law director's office, which is prosecuting this case. And you don't get it from the court. Any attorney knows that. You might want to reconsider representing yourself, Mr. Colton.
Yes.
Okay. Do you have any other noises you want to make before you leave this courtroom?
No, thank you.
Then get out of here without making a noise.
Yes, sir.
Bye, have a great time.
And that brings this case to a close. A clear example of how quickly courtroom dynamics can shift when preparation, attitude, and understanding collide. If you found this breakdown insightful, engaging, or thought-provoking, Make sure to share your perspective below and stay connected, so you don't miss what's coming next. More compelling moments and real courtroom encounters are on the way, and you won't want to miss them.